Thank you, Sean. I call Jim Allister.
Marriage is a coherent thread, keeping society and families often together. So it inevitably follows that when you embrace easy, no-fault divorce, then you cheapen marriage. Marriage is based on solemn vows, and no-fault divorce demeans, diminishes, disregards those vows, and can inflict upon an innocent party in a marriage the greatest possible hurt. That they who took their vows seriously can now be faced with a situation under no-fault divorce where, in spite of that, and contrary to their wishes, they can be divorced without the right to ever be heard. That is the point that cuts to the very issue affecting innocent parties. Yes, I'll give way.
I appreciate him giving way. Given that many more people, often in tragic circumstances, are more likely to engage with divorce law in their lives than they are to be directly affected by, just to pick something at random, the regulation of goods moving across the Irish Sea, does he think it's more of a problem for basic rights, in terms of, for example, one's ability to access divorce, that there should be a divergence in the law between Northern Ireland and England and Wales in relation to divorce? Is that not a problem, but divergence in terms of regulation of goods is?
The member for an extra minute.
And is entitled to be treated by this Assembly as it so wishes. But the fundamental is this: a party in a marriage can now find themselves under no-fault divorce, divorced without the right to ever object. Because remember what Section 1 of the English legislation says. It says an application, which can come from either party or both, must be accompanied by a statement by the applicant that the marriage is broken down irretrievably. The court dealing with an application must take the statement to be conclusive evidence that the marriage is broken down irretrievably and make a divorce order. So the biggest scoundrel that's ever been in a marriage, the biggest philanderer, the most cruel individual who has mistreated his wife and his children for years, can suddenly present as a petitioner claiming the marriage is irretrievably broken down, and the court is obliged to accept that without ever hearing from the innocent party, without ever proceeding to making an adjudication. Now that is a step far too far. I could understand it from a legal point of view if both parties to a marriage mutually wanted to make an application that their marriage was over. But the real menace in this is that the innocent party can have divorce against their will put upon them, and marriage breakup is the greatest cause of poverty in this country. So a wife who can find herself suddenly, against her will, divorced, maybe homeless, children falling into poverty. Why? Because this Assembly thinks it's a great idea to have no-fault divorce and enable that infliction upon family and children. Yes, I'll give one.
The point that the member makes in relation to the financial settlement, is it the case that the financial settlement is different to the actual dissolution of the marriage? So the point you're making is contrary to the actual dissolution of the marriage?
Yes, the ancillary relief follows from the divorce. But once you have the divorce, which you can get after 6 months, you could be married today and initiate divorce tomorrow. And within 6 months under the English bill, you can be divorced. And the ancillary relief, the disposal of the assets, then is next attended to. Now, do you think it's going to be an advocacy of contentment and ease of those ancillary relief processes to have a wife who didn't want to be divorced, who probably is on the lesser share of the ancillary relief, to suddenly find she has to face that? The house that she thought was giving her cover is gone. You're putting that woman in an impossible position. Now, again, I'm back to the point. If both of them want to say, we want to disavow our vows, we want to end the marriage. That might be one thing at a secular level. But for one person to say, in spite of you, I will inflict divorce upon you, anyone who thinks that will make the ancillary relief easier, that's going to build up great hostility and far more difficulties in all of that. And you have children who might have never known that their father or their mother was minded to suddenly go for divorce, suddenly has that thrust upon them. So I think this House should be very careful before rushing in to the fashionable idea that what is marriage? Forget about it, walk in one door, walk out the other, and who cares? And that's the attitude of no-fault marriage, illustrated by proponents in this House who weren't even prepared to take an intervention.
Oh, God. Question is that the motion stand on the order paper be agreed. All those in favour say aye. Aye. Contrary if any noes? No. The ayes have it. The ayes have it. Just heard one dissenting voice. Okay, so item 7 on the order paper is the adjournment. The question is that the Assembly do now adjourn. The Assembly is adjourned.